After the court has held oral argument, the justices meet once again in the Chief Justice's chambers. They meet on Wednesdays and Fridays. On Wednesday, they meet to discuss the cases they heard on Monday and Tuesday, and on Friday, they meet to discuss the cases they heard on Wednesday. This conference is very similar to the conference in which they discussed whether or not to accept the cases for review. That is, the Chief Justice goes first, all of the other justices speak in order of seniority, and nobody else is allowed in the conference room. During the conference, each justice casts a vote, but it's important to keep in mind that these votes are tentative, and the justices are free to change their minds at any time up until the time the decision is released to the public. So, after all 9 justices have a chance to vote, a tentative winner is known. But then the most important tasks lie ahead, because the main opinion must then be assigned. The Supreme Court's most important work is the writing of their opinions. The court decides not only disputes between specific parties, but it writes legal opinions that justify it and create precedent for the court itself in later cases and for lower courts in later cases. And so the main opinion, every case has one, and every case has one author, or I should say every opinion has one author. And you can identify the name of the author because it's right at the beginning of the opinion. And each of the other justices is faced with a choice. Are they going to join the opinion or not? So there's an author, and then other justices can join the opinion or not. So the question then is, who gets to write the majority opinion? And the court follows a simple set of rules. When the Chief Justice is in the majority, he gets to decide who writes the opinion. In other words, when the Chief Justice is on the winning side, he gets to assign the majority opinion. But of course, the Chief Justice isn't always in the majority. Sometimes the Chief is in the minority, and when that happens, the most senior justice on the majority side gets to make the opinion assignment. So for example, on today's court, often John Roberts and Ruth Bader Ginsburg vote separately or distinctly, and if John Roberts were in dissent, then Ruth Bader Ginsburg would often get to make the assignment when she's in the majority. Now, opinion assignment is extremely important, or it can be extremely important, as we can see in the 1986 case of Bowers v. Hardwick. Bowers v. Hardwick involved a Georgia law that made it illegal for 2 individuals of the same sex to have sex. It criminalized homosexual sodomy. And the question in Bowers v. Hardwick was whether that law violated the constitutional right to privacy. Well, when the justices went into conference, they initially voted 5-4 to strike down the law and say that it did violate the constitutional right to privacy. But then something happened. Justice Harry Blackmun was assigned the opinion, and he wrote a very strong opinion, a strong endorsement of the rights of gay couples to construct their lives as they wished. And this was then circulated to the other justices, and it apparently alienated Justice Lewis Powell, who was a moderate justice, but his old-fashioned sensibilities seemed to be offended by this particular opinion, and as a result, Lewis Powell switched sides, and that had the effect of changing the court's vote in the case. They went from a 5-4 vote in favor of striking down the law to a 5-4 vote upholding the law, and in fact, that's exactly what happened. So they upheld this law, and Lewis Powell later on came to regret this. After he left the court, he gave an interview, and he said one of the biggest mistakes he ever made was changing his vote in this case. He regretted it because what it meant was that for another 20 years, states could throw people in jail for simply having sex with their lover. And this decision was eventually reversed, but again, it took almost 20 years. It was reversed by the court in a case called Lawrence v. Texas in 2003. But as you can see, the way an opinion is assigned can be extremely important. And so, in fact, we know it's so important that Chief Justices and others who make opinion assignments do not do so randomly, that there are certain patterns that they follow that we have discerned. So let's go ahead and take a look at a few of those. And one consideration that we found is that Chief Justices are more likely to assign opinions to themselves than to anyone else, all else being equal. We take everything else into consideration, but they do have the power to assign it to themselves, and they do assign it to themselves more frequently than we would expect simply by chance. And political scientists have discovered that this is particularly true in important cases. Certainly it doesn't happen always, but when the court hands down a particularly important case, the Chief Justice, if they're in the majority, are more likely, even more likely, to give the opinion to themselves. So, for example, Dred Scott, which is very famous, although infamous for being such a bad decision, that was written by the Chief Justice Taney. Earl Warren, Chief Justice Warren, wrote the majority opinion, in fact the only opinion, in Brown v. Board of Education. And in the Obamacare case, Chief Justice Roberts wrote the opinion in that case, and we could find lots of other examples. So they overassign to themselves. We've also found that one of the things that motivates justices in making opinion assignments is equity, and that is simply spreading the workload around. There's a lot of work to be done on the court, and any boss tries to keep things fair, and so Chief Justices attempt to hand out opinion assignments to make sure that everybody gets about the same amount. But the thing is, this is harder for some justices than it is for others, because the Chief Justice typically will vote with some justices more often than others. For example, Chief Justice Roberts is probably far more likely to vote with Samuel Alito and Clarence Thomas than he is with, say, Ruth Bader Ginsburg or Sonia Sotomayor. And as a result, the Chief Justice does not have as many opportunities to assign opinions to people on the other side of the ideological fence as he does to those who are in agreement with him most of the time. And as a result, the Chief Justice tends to overassign opinions to justices on the other side of the ideological spectrum whenever possible. So what that means is Chief Justice Roberts may not vote very frequently with Ruth Bader Ginsburg, but when he does, he's going to be more likely to give an opinion to Ruth Bader Ginsburg simply because that's one of the few opportunities he will have to do so. So they tend to overassign to their enemies or the opposite side on the ideological spectrum. And we got to keep in mind, of course, that not all Supreme Court decisions are 5-4. Many of the court's decisions are unanimous. The third consideration, although this one seems to be fading according to political scientists, is something known as the freshman effect, and this is probably something you've encountered in your own life. And that is that when somebody first joins a court, there is a period of transition or a period of apprenticeship. And so one manifestation of the freshman effect is that there has been a loose tradition of assigning a new justice a unanimous decision as their very first opinion. The idea is that when you're a new justice, we don't want to throw you into a contentious 5-4 case right away. Let's give you an opinion where everybody's in agreement as sort of a way to break the ice and welcome you to the court. And once upon a time, the freshman effect also meant that Chief Justices tended to assign fewer opinions to those justices who had just joined the court and who were in their first year on the court. And you can understand this when you get to a new job. Normally there's a period of training and you don't have quite as many duties, and then as you become more capable, your workload increases. The same thing once happened on the court. This effect seems to be fading, however, and that's probably because so many of the justices now have already served on the Court of Appeals, and they already have an experience being on an appellate court and writing appellate opinions. A fourth consideration that Chief Justices look at when assigning opinions is just getting the court's work done. The justices like to leave town by the middle of June so they can scatter off and usually teach law school over in Europe and make a bunch of money. And as a result, the Chief Justice has to take that into consideration when making opinion assignments. The fact is, some justices write faster than others. And again, you know this in your own life. Some people are fast, some people are slower and methodical. And for example, David Souter was notoriously slow in writing his opinions, and so you would always be waiting until the end of the term, and you almost always knew that on the final day of the term you'd have several David Souter opinions. And so one thing that we've discovered is that Chief Justices tend to slightly over-assign opinions to faster justices. So, like in many things, the more competent you are, the more work you get for yourself. And that's true on the court as well. And of course, we want to keep in mind that when the Chief Justice makes opinion assignments, one of their big considerations is they want to get their way. They want not only the case to have the outcome that they desire, but they wish to make sure that the opinion is as close to their own opinion as it could possibly be. And the way that they assign the opinion can increase the odds of shaping the opinion in their way. And later on, we will talk about an example of that when we talk about the case, a civil rights case, Patterson v. McLean Credit Union, in a couple of weeks. So one last thing to mention in this particular lecture is the notion of multiple opinion authorship. This is very, very rare, but when it happens, it's extremely important. As I've already indicated, the vast majority of all opinions have one author, a single author, and that author is named. And then the other justices have a decision to make whether to join that opinion or not. Exceptions to this model are very rare, but once again, when they occur, there is something that we should take notice of, and we should try to understand why this occurs. Because occasionally, you have opinions that have more than one author, and they are always symbolically significant in some way when there is more than one author. And these are often related to issues of legitimacy. If you'll recall, we said much of the way the court operates is dictated by their desire to maintain a sense of legitimacy. And multiple authorship, when it occurs, is often related to the concern for being seen as legitimate. The most obvious example occurred in the case of Cooper v. Aaron in 1958. In 1954, the Supreme Court decided the case of Brown v. Board of Education. They said that schools in the South and elsewhere had to integrate and allow black and white children to go to school together. And of course, there was massive resistance to this decision in the South, with violence and all kinds of other opposition brought by private citizens and by the government itself. And Cooper v. Aaron stemmed from the violent confrontation that occurred in Little Rock, Arkansas, when the city was trying to integrate the schools, but they were blocked violently by the governor, who sent in troops to stop this from happening. And as a result of the chaos, Little Rock asked the court to postpone the plan for 2.5 years. They said, we want to let things die down a little bit, and we'll come back and we'll do this in 2.5 years. Well, the court did not take kindly to this, because they felt that this was a direct confrontation to their, and direct opposition to their decision in Brown v. Board of Education. And so they said no by a 9-0 vote. But it's not the fact that they said no that's so significant. But what's significant about this case is that all 9 justices signed a joint opinion. This is the only time this has happened in all of the court's history where every single justice was one of the authors. And they basically said that the government cannot create chaos and then use that chaos as justification to defy the United States Supreme Court. And in saying this, they tried to make a strong statement about the court's legitimacy. The basic decision in Brown was unanimously reached by this court only after the case had been briefed and twice argued and the issues had been given the most serious consideration. Since the first Brown opinion, 3 new justices have come to the court. They are at one with the justices still on the court who participated in that basic decision as to its correctness, and that decision is now unanimously reaffirmed. This is a very significant and dramatic statement. The court is saying, look, we decided Brown v. Board of Education unanimously and said you had to integrate. 3 justices have left the court since then, and 3 new justices have joined the court since then, and we're still deciding this case unanimously. And not only that, we are issuing a unanimous opinion. So they were sending a signal to the South that the court was never going to change, that they could wait 2.5 years, they could wait 25 years, but the court was always going to insist that its mandate in Brown v. Board of Education be carried out. And the joint opinion, along with these words, sent a message that we are placing a line in the sand and we will tolerate no further opposition. Very dramatic moment in the court's history. Another interesting example occurred in Planned Parenthood v. Casey in 1992. Of course, abortion has divided the country pretty bitterly ever since Roe v. Wade was decided back in 1973. And of course, the court has decided many cases over time involving abortion restrictions since then. Well, back in 1992, there were 3 justices who were kind of in the middle. Sandra Day O'Connor, Anthony Kennedy, and David Souter, and they got together and they said they wanted a compromise. They wanted to come up with a compromise to see if they could steer a middle ground both for the court and for the nation. And so they got together and they wrote a joint opinion. This was an interesting case because there was no majority opinion, but they decided to write a joint opinion. And so their opinion was authored by 3 justices rather than 1, which was symbolic. They wanted to indicate their compromise, that there was somebody, Souter, from the more liberal wing of the court, O'Connor and Kennedy, who are from the more conservative wing of the court, and that they could get together and come up with a compromise. And what they developed was something called the undue burden standard, saying that states could not burden. They could pass abortion restrictions, but they couldn't pass any abortion restrictions that placed an undue burden on a woman's right to choose. Now, of course, what an undue burden is was left for later cases, but nevertheless, this was seen as a compromise between banning or allowing states to ban abortion altogether and allowing no restrictions on abortion at all. Now, the interesting thing is that the undue burden standard has never been established as precedent by the court, but it's still the standard that the court uses. So in any case, that's it for this lecture. Next up, we're going to talk about the 4 different types of Supreme Court opinions and why they matter.